At the table, Alex Nunn is one of our financial planners. He's the guy that if you say, I want to do investing with the bank, he's the guy that's going to help in doing that. David House is going to be one of the expert speakers here. He's a salaried guy at the bank. He is a financial planner, but what he does is creates the financial plan. And so he's a master's in tax, he's a certified financial planner, and he's certified in business exit consulting. Yes?
Correct.
Kim King is a 5-star rated attorney. He does a lot of estate planning stuff, which really feeds into all of this stuff as well. But he does, we've read operating agreements that he's formed for companies, and he deals hands-on with the mediation litigation piece of this. And so born out of this is, where do we start? What kind of information can we give you, and where does it go? We're not going to go into names of individuals that you know in the community that are currently going through these issues. Obviously, it'd be a lot more meaty of a topic if we could, but we don't know if there are conflict of interest issues with who's representing who. So it's going to be a little bit high level to that extent. And Kim has printed out and left on the front table copies of his pieces of it. So if you want to grab one of those on the way out, that's great. And we've got Will here recording it. So once we clean it up a little bit, we'll have a YouTube video link that we can share in case there's someone else that you think might value listening to this. So I will hand it off to Kim and David to take over.
Wonderful. Thanks, Ben. Thanks for coming today. My name is Kim King. We have a small law firm called King & Wood here in Tallahassee. We're business...
I don't think your mic's on.
Turn it, yeah, put it a little there, put it a little closer to you.
Yeah, good. Can you hear me now?
Nope.
You might have to,
Okay.
you might have to get it back and forth. At a right close to your mouth.
Sure. Yeah, sorry.
Logistics.
Okay, how about now? How about now?
Yeah.
Yeah, good? Okay, good. So I appreciate this opportunity to have a conversation with you about some of the issues that we see in our business and estate planning practice all the time. And you'd think that I've done, practice law for more than 30 years, and we're outside general counsel for lots and lots of small businesses. We have lots of families we help through estate planning. We do the probate side of things, and we do litigation when things go wrong or they don't go as planned. And so we see how the planning piece that's involved in your business operations fits in as an important component of continuity. And so the topic today that Ben asked us to join in on is what we can do on the planning side and implementation side to try to help make sure continuity of the businesses that you've worked so hard to build. I view it, I tell our clients in meetings about planning that it's really an exercise in stewardship. You've been given gifts and resources, connections, you've built wealth, and you have I see myself as having a duty to be a good steward of those things that have come my way. And part of that stewardship also is, I view it as trying to help other people with their business operations to make sure that our community, our larger community, is stronger, because small businesses create the jobs that drive the American economics. So that's kind of a high level. So the topic today, Ben and David and Alex, is planning for business continuity. We're going to talk about entry and exit of equity owners of closely held corporations and LLCs. And just because this talk is being recorded, today's July 25, 2019, so if cases come out tomorrow, this talk is already dated. In the last 2 weeks in our practice, we've...
Speak to the mic in front of you.
I'm sorry. In the last 2 weeks in our practice, we've had two, and I'm not going to give any details that would let you know who these folks are, but we've had two shareholder fights that finally got resolved. One of them was a fight that went on for 2 years. The other one went on for a full year. And they are disagreements in very successful companies among shareholders. One was where we had one generation passed off to the next, and many American businesses don't survive that transition from one generation to the next. There's some techniques that you can use in planning and implementation to try and give better odds of success to the next generation. But even when you do, things can go wrong. And then there's the other one where, people build businesses together, and it's a very successful business. It's an informal relationship, and the power structure isn't dispersed enough. For example, like the board of directors is too small, there's no independence on the board of directors, and it allows one shareholder to try to take advantage of the other. And those fights are really nasty, really expensive. One of them was in court, and the other one we managed to resolve earlier this week through a process called pre-suit mediation. And everybody comes out a winner in a sense, but also everybody comes out a loser in a sense in any compromise of a claim. So what can we do? Let me just tell you what we see on the planning side. And that is lots of great ideas, lots of planning techniques that are available, but where we fail as lawyers, to the extent we have control of it, is convincing our clients to actually implement the plans that we've outlined for them. So it's one thing to design a trust that's going to hold assets, but if you don't move assets into it, then the trustee has nothing to manage. If you have employees and you have an opportunity for employment agreements, this is an asset protection issue. If you don't have an arbitration clause in your employment agreement with your employees, you can do it through a manual and have them sign it. You just exposed your company to great asset protection risk, and that part is really avoidable. So implementation, which is where David and Alex really come in and can bring extra value. People on the finance side ought to work with the lawyers and the certified public accountants as a team, and we're going to talk about teams in the planning part of things. That ought to happen, that conversation ought to happen along and along. Go ahead, Dan.
All right, I hope everybody can hear me here. Is this pretty good?
A little closer.
All right, very good. All right, so I am the financial planner on the team, so I have the privilege of raising lots of questions and issues that I see throughout, and then bringing in smart people like Mr. King to my left to figure out the solution to those problems. But I'm a numbers guy, so I really like to start with a few stats. All right, so we have about 25 people in this room today. All right, so let's just use that number, 25. Let's assume we all have our own family-run business. All right, and I think we've heard these stats, but let's kind of bring this home real quick. If we have 25 family-run businesses, what number of those, statistically speaking, will make it to the next generation? It's about 30%, so about 7 to 8 of the people here, 7 or 8 of those people here would actually have that business go to the next generation. Beyond that, so what percent makes it down to another generation below that? About 4 of us here. About 4 of these businesses make it, and beyond that to a third generation further, about 1 out of 25. So just one of those people who would actually make that to a third or future generation. And there's many reasons for that. I mean, sometimes it's planned, sometimes that's a good thing, sometimes that means that we did a great job growing our business and we had an offer that we could not refuse and we chose to sell. Public traded company, private equity group, whatever that might be. Sometimes that was a design plan, but not always. We've seen quite a few situations, we'll talk about that some, whereas mom and dad started a business with the goal of transitioning down to the kids, but not every one of G2 often wants to be involved in the business. So what do? Let's say we have 2 children, we want to transition us down, but as they grow up, only one wants to be involved in the business. How do we handle that? What's fair versus equal in the transition of the business? Do we have to try and equalize our estate? Do we say, well, my daughter's been involved in the business, I'll give the business to her and try and find other assets to give to the son? Or do we say, you know what, she's worked with us full time, what's her sweat equity worth? All right, so I've seen a lot of individuals start that transition during lifetime and say, well, you've been working with me for years and years, let's start that transition process. All right, and there's really no right answer to that. It's a very case-specific situation, but that's something that we see all the time. So if you're thinking about that, don't feel like you're alone. That really requires conversations with both the advisors and the family of what we want to have happen. I will say generally people like to try and find a way to equalize. Probably the worst thing we can do is just assume that my children that are involved in the business and my children that are not involved in the business will all kind of figure it out down the road. And we just have our will or our trust or wherever distribution provisions we have that just gives everything equally. Everything to my surviving spouse, if they're not here, everything to my kids, and they'll kind of figure it out. I will tell you, when you have children that are involved in the business, they have very different goals for the business and most importantly, distributions from the business than those that are not. So it's very important to have those conversations early on. So I'm going to turn it back to Mr. King to kind of take this conversation a step further.
Sure. So when you have this conversation with, say there's an adult child who's working in the business, and you have an adult child or maybe multiple other adult children who are not involved in the operation of the business, never have been, really don't want to be. When you have that conversation with all of them, which you should as part of this planning process, you need to be prepared to say, child number one, who's been in the business, has built this sweat equity, and this is what my plan is going to be. I'm going to have other wealth that I'm planning to pass down to the others of you in my bloodline, but I'm not going to give you the business. So if you tell them up front what the expectation ought to be on their part, you can avoid a lot of resentment and possible litigation on the back end when we're trying to administer a trust or probate an estate. Fighting among the next generation is wasteful, and it can destroy a business. So that planning piece of it, then you're deciding you've got somebody new who's going to come in, and that scenario, it was the next generation of an adult child who's been working in the business. Well, how's that child going to come into the business to create a transition over a few years before owner retires? Or suppose you don't have a child who's been in the business or one who's suitable to do it. You need to try to preserve that wealth through continuity, through selling stock to somebody else, for example, if it's a corporation. You're going to bring in an outsider. Well, what are the terms of the deal? So when you're bringing in, you're basically selling equity securities to somebody else who's coming in the business. There are all kinds of securities laws that you've got to comply with. Disclosure, if it's a small business and everybody lives in Florida, for example, okay, you got some exemptions you can work with. Nevertheless, if somebody's paying cash for one of these, for the stock, or you're selling it over time, you need to have a clear deal, and then you need to have it properly documented. Important pieces of that is to have a shareholders agreement, if it's a corporation, or an operating agreement, if it's a limited liability company. They work the same way. Operating agreement is simply shareholders agreement plus bylaws built into one document. That's how you think of it. And a corporation has, you can have shareholders agreement and you can have bylaws that are separate. But you want all of those. You want the terms under which this person coming in is going to own his stock. What if he decides he wants to leave? What kind of liquidity are we going to offer him? What if he gets poached by some other competing firm? Do you want to have some kind of an employment contract with him that restricts his ability to go work elsewhere and take our business secrets with him, even though the legislature has given us some default rules on that and some enforcement mechanisms through trade secrets laws? But if you cover it also in your corporate documents, your shareholders agreement particularly, then you're going to have a much better chance of preserving business continuity, because you're going to disincentivize somebody from doing something that's really bad for your business.
Absolutely. And if we start looking at some of those lifetime transfers, let's use the same example we're referring to, where one child might be involved in the business. We want to start making that transition during life. There are certain caveats to watch out for. Obviously, the tax impact, the gifting impact, Mr. King can reference. But one other thing, just from a financial planning and more of a bank and a lending standpoint, I want to mention is I've seen this quite a few times. I have a business. I say my son's been involved in this. I give him 25%, and that way we can start that transition process. Well, next time they went to renew the loans and look at the loans, suddenly that bank said, well, now you are a partner to this. We need you to give your personal guarantee as well. That was a shock for a lot of people. Now, I'm not going to speak for every bank, every term, but that is something, if you're considering transitioning during lifetime, really look out for those pitfalls and making sure that next generation is ready to guarantee something they really have no control over.
So I wanted to talk for just a minute about techniques that one can use in the design of the plan for business continuity, and focus on either shareholders agreement or the operating agreement, and what might you put inside there. Remember, what we're trying to do is to stay out of court. We want to have a business relationship that has flexibility in it, and it has some techniques built into it, so that when disputes arise, and of course they will, we're human beings, and there's money involved, so we're going to have disagreements from time to time. If we have agreed going in that in the event these kinds of disputes arise, they're going to be resolved through a certain process, we have just achieved a lot, because we can resort to those processes later when we have a disagreement. So you can have built into either a shareholders agreement or an operating agreement a mechanism that says, when we have a dispute among these co-owners of this business, here's how we approach resolution of those disputes. And you can say it. We have a multi-step process. We start with informal discussions. Fine. Maybe we've got a disinterested board, and I'm going to talk about that separately. But if we have a tiebreaker, a person in the wings who can come in the event there is a deadlock, that's a great technique for staying out of court. So we have this mechanism that says, okay, we're going to talk about it first. We might then have a mechanism where we step it up and we bring in a neutral from the outside who has expertise in this industry and can help us, find common ground and resolve this particular dispute. But then we might have it kick out into formal pre-suit mediation, where the rules that would apply in the event where you're in a court case, where the court would send you over to a professional mediator, those kinds of techniques where you go back and forth. It's kind of like shuttle diplomacy. You remember the old days, Middle East diplomacy, where a guy would get on a jet and go from one country to the next, and he'd bring deals back and forth? I went through that Tuesday of this week, and we managed to resolve a shareholders dispute through it on a pre-suit basis. So you can have that in your shareholders agreement or your operating agreement, and you can manage to stay out of court by having that mechanism and insisting that anybody who's a shareholder, who becomes a shareholder, or an equity owner, if you're a member of a limited liability company, anybody who comes in is bound by those rules. And then, if you want to stay out of court, you can have an arbitration provision. There are arguments on both sides, and that's where you're required to follow. It's a private judge, an arbitrator is. You stay out of court, it avoids public scrutiny of your disagreement, which might advantage your business competitor. If the competitor knows that you're having fighting going on inside, he might want to take advantage of that. That would be normal. So you have this mechanism that's spelled out in your documents. You might also have a mechanism that says, we're going to have a requirement of basic fairness. We're not going to have there's a technique that sometimes minority shareholders can be treated with a distinct disadvantage when they get ganged up upon by the majority owners, and that's sometimes in some states what's called shareholder oppression, and you can have a squeeze out problem where you force somebody out. Here's a technique, and you may have this in your agreements already, and I don't want to plant any seeds of how to disadvantage your minority co-owner, but here's what you could do. You could force them to sell at a discount because their shareholders agreement or their operating agreement says, in the event you quit being an employee here, you can no longer serve on the board of directors. You can't continue to own an equity position in this company. And what's the formula? What's the price on the way out? That price is a formula that probably nobody paid any attention to. Maybe it's book value, which is going to get a really, really low price. Maybe it's a fraction of, maybe it's something more generous, like a percentage of, your percentage of ownership multiplied by the going concern value of the company. But even then, you're not getting the full value of your investment in the company. So thinking through on the front end, through these shareholder agreements and operating agreements, what's going to happen on the back end, on the exit, is an important opportunity for avoiding litigation.
But isn't it easier just to have a very short operating agreement and you have that one child who's always been that decision maker and let them continue to make the decisions after you're gone?
Yeah, no, it's not. Concentration of power can be very problematic. There might only be one logical choice in a super small business, but if you've got other owners and this one guy with all the power starts doing stupid things and things that are unfair, and maybe he's under the influence of a spouse, for example. You always have this in-law problem. The in-law who's thinking, oh, my spouse is working inside the company, and she ought to be bringing more money home to me, so I'm going to say, you need to have the company force out cash flow to our family and not leave money inside the business to help maintain its capital level so that it can grow. So you're going to have these tensions these forces that come to bear on this either president in a corporation or manager in a manager-managed LLC, Those kinds of influences, you can't really see them. You can think they're probably out there, but you may not see them right away. So providing a mechanism so that power gets shared when those kinds of events come up is an important one. A couple other things on that. So you do need a leader, right? But you can restrict the authority of the leadership in certain areas. You say, okay, we're going to force out distributions for taxes, for example. I mean, the CPAs in this room will tell you about, I mean, how important that is if you have a company that's an S corp, for example, and the tax effect gets passed out to the shareholders on paper, even if there's no cash to go with it. And now this other, typically as a minority owner, has to pay the IRS money based upon the income of the company, and he never got any cash flow because the president, doing the opposite of what I just told you, decides we're going to leave all the cash in the company because my agenda is to grow the company, and I have a lot of my own wealth, and I don't really care so much about this minority shareholder or minority LLC member who doesn't have as much money. So I take advantage of that wealth disparity, and I'm building things that are in my best interest and not his. So we have a fiduciary duty issue that we could talk about, but you can avoid at least that issue by putting in your documents that says we're going to have distributions for taxes, and we'll have a formula for making sure that happens.
You have one other bullet point here that I want to make sure we address, and that is to restrict the transfer of ownership interest during lifetime and after death. So I'd be curious to hear your thoughts on what you'd like to put in there for these documents for while, again, G1 is still around and when we have G2 down the road. What do you like to see for that?
Yeah, so generation 1, generation 2, founders, generation 1, next, the adult children who are coming in, assuming they may not be children, but the next generation that's coming in. Restrictions on transfer of the equity security interest, that's what this topic is. And so you don't want to find yourself in business with a stranger. And that can happen if it's, for example, your co-owner ends up having a judgment creditor. And that judgment creditor then comes and tries to levy execution of the judgment on the stock or the membership interest, and all of a sudden that person has a co-ownership, and what he'll do is he doesn't really probably want to come in. He's a creditor. He probably maybe he bought the paper from somebody. All he wants to do is get some quick cash, and so he'll be able to use a strong arm technique to get you to pay more than you ought to pay. So how do you handle that? Well, you have restrictions. You say in certain events, and you can pick them. The departing shareholder is required to first offer. If he gets an offer to sell it, he must take that same offer up to the other shareholders, and then they might have a pro rata opportunity to buy those shares so that they don't find themselves in business with a stranger. You can have another force that is a put so that, hey, if I'm leaving, I have a right to make you buy it back. Those are dicey because there's a cash flow issue that comes along with that. And you don't want to find yourself, somebody dies. You don't want to find yourself in business with that person's, you might not want to, with that person's spouse, or if that guy was the surviving spouse with a nephew or something. Now you've got a co-owner who doesn't have any interest, any business being in the business. So you can restrict the transfers of those security interests during lifetime. Say you can't sell it unless you first offer it to the other people, and you have a formula for the price on that. You might have a payout period. It says, and the payout period is over a period of 10 years, and you might set an interest rate or some kind of a target rate in there, so that you have a mechanism for what triggers the purchase right, and then how it's going to get paid for. Spread it out over time.
I want to ask one more leading question, if I may. So I've had a lot of clients that have had the business, and the son-in-law, the daughter-in-law, or even just the next generation, they wanted to bring them in on the business. What do you like to see? What are some best practices that we should have when we want to bring in the next generation? Should you require outside experience? Should you have any kind of a parameter on that, or just kind of leave that more open-ended? What do you like to see?
Well, first of all, it's really, the question really doesn't, it draws on our experience as lawyers, but it's really not what we do. And, Ben, why don't you, I'm sorry, you want to talk
No,
about that?
I want you to talk in front
I'm
of
going to talk in front of this, okay. So the suitability of the guy who's going to come in to lead. So that's a bunch of intrinsic factors. Of factors that are extrinsic to the business structure. So it's more touch and feel. So is this guy suitable? Does he have experience? That's really I would really push that off on you guys.
Okay,
So,
that's tough. I guess I'm just thinking, I've been in several meetings over the years. I mean, one keeps coming to mind in a boardroom down in Tampa Bay where we had 5 children. 3 were involved in the business, 2 weren't. So one of them wanted to start to transition into Generation 3, so his son, to get him involved in the business. That worked out well. But then there was another partner who wasn't involved in the business, wanted to bring their child in, and they really had no interest in it. They were just looking for that summer job, that easy money. And that was a tough thing to have happen there. And so that always kind of goes back to, do we set the rules or not? It's always worth having a conversation. When everybody's still fine, when everybody's still healthy, getting along, that's when we discuss what all these what ifs. Do we want to put this in here? Do we want to have something in writing to say, here's how we're going to handle this? I will tell you, almost every time, the second generation gets along very well when parents are still around and running the business. Things, I hate to be cynical on it, but things do change so frequently when we move down to the next generation. So I encourage it, any of the family businesses that we have here, or any advisors for those, have those conversations. It's not fun to talk about, when I'm gone, what's going to happen. But it's so important. And again, it's important to do when everybody's fine. When we talk about the valuations and how we're going to exit the business, it's important to do when we don't know who's going to go first. And so if I'm a partner, if I'm in a partnership with Mr. King over here, and we want to value the shares, if one of us were to exit for death, disability, divorce, retirement, whatever that reason might be, it's important to figure out how we're going to value those shares when we really don't know who's going to go first. You used a great example the other day on when you have 2 children, if you have some children, you always let one of them cut the candy bar in half and let the other one pick it, right? And that's such a good example, because have those discussions when you don't know which one's going to go first. And this kind of leads me to a lot of the personal planning topics that I think are just so important when we're thinking about the business. So as business owners, we tend to focus on the lifeblood of what kind of creates us, what kind of creates our business. And I haven't met a business owner yet that only spent 30 to 40 hours a week on their business. If there are, I'd love to see what your interest is and maybe get into that. But oftentimes, and not to generalize, oftentimes when we do stay business to business, we tend to neglect some of the outside investments, some of the outside personal planning. And I just want to bring up a couple instances where maybe we shouldn't. All right. One case, one situation I've seen a lot in the last 10 years or so, which always baffled me to start. Now, I guess I'm getting a little numb to it, is after 2008. It's just a lot of the lending rules and mortgage rules changed. And I started encountering a lot of bankers coming to me and saying, hey, my client has a business worth $20 million, but I can't give him a mortgage for $150,000. Why not? Well, the tax return showed no income or very little income, and that just started creating a lot of issues for the lenders, for the banks, for the mortgage companies, things like that. That's always a fine line. I mean, I haven't met anybody yet who wanted to pay more tax and earlier. It's always the less tax and later concept, right? I mean, that CPA is going to hopefully attest to that. But there is that fine line on what do we need to report, especially if we do think that down the road we're going to need a loan. Down the road, we're going to want to buy out somebody else. We're going to want to buy out our partner. It is important to start thinking several years ahead to start to kind of get your financial house in order. Sometimes we do see instances where the selling partner will agree to sell to that buying partner, and they'll have a fair term over, call it 5 years and a low interest rate. But oftentimes that exiting partner wants their money right now. All right, and so how do you accomplish that? Well, it does behoove you to have your balance sheet outside the business in order to make things easier for everyone. I mean, it truly does. And so just kind of thinking about that, most of I'm sure nobody hears this way, but we oftentimes, as a business owner, have, if we look at our net worth as kind of a pie, about 80% is the business, 10% maybe personal assets, the cars, houses, boats, things like that, and the rest is the other investments. And those other investments, I won't say every time, but well over half the time, are in cash. And they've been sitting in cash for a long time. I want to kind of remind you, it just behoove you that take a look at what you have outside the business and make it work for you. All right, subtle changes for what we have outside the business will make substantial impacts over the long term. It's going to help you out now, it's going to help you out down the road. It truly will. So again, whether you're the buyer or the seller, it's going to help. And also, I mean, we're going to talk later on about valuing and understanding what we call the value gap, how much you need to net from that transaction. Well, if you've already done that homework ahead of time and started to let those assets outside the business work for you, it's going to make that conversation a lot easier and maybe allow you to facilitate your goals of getting us to 1 or 2 kids and keep that business inside the family. Because if we don't, well, sorry, I can't afford to sell it to my family or my favorite employee. I need as much as I can get right now to exit this business. And so while we don't think, and we wouldn't have thought that today's going to be talking about your own personal investing and your own personal planning, they really do go hand in hand. They truly do.
Thanks. All right, so we've talked a little bit about the intergenerational changing from parents or owners to their kids, potentially, or someone that's family related that's working close by. What if you have now an 80-20 ownership and you decide that one of the two of you has an issue? Maybe suddenly it's a cancer onset, it's an accident that happens, it's some life event. Maybe you have a spouse that moves out of town and you need to go follow them. And now you're no longer providing income into the company. And so there has to be some plan for having a person leave. You mentioned some different business valuations and some language. What are the basic considerations that come in? And then also, if you decide you're going to bring in, maybe you're the majority owner and you want to start fractionally distributing some of that ownership to other people because you want them to have a vested interest in your company. How can that be a fair distribution since you're the big cheese, the major owner, and then you have other people that have lesser amounts and you're bringing them in? What are those things that you really need to think about and consider for those variables and those changes of who owns what?
All right. I think the things you need to consider is not only what is the value worth, but also what do we need to net from this transaction. It goes a lot of times to that fair versus equal concept. All right, who do we want to benefit and how do we want to do this? Are we the type of owner that needs to, are mentally ready to get out right now and need as much as possible? Or are we trying to make sure we benefit the children, the next generation, whatever that might be? And so for me, it's long-term planning. And it's also, it kind of goes back to getting the balance sheet right on both the business and the personal side. So let's say, for example, for whatever reason, my business partner, whether they own 20% or 80% or anywhere in between, they need to exit and I need to buy them out. How do I facilitate that? And so oftentimes when we think about buy-sell planning, we do a great job at working with our attorney to get a buy-sell agreement in place. And then despite your many efforts, it doesn't get funded. We don't have the funding mechanisms, or if we do, they kind of fall off the wayside. I will say that when we think about buy-sell planning, we oftentimes just think about, okay, I'm in business with Mr. King. One of us passes away. Great, we fund his life insurance. We'll buy a life insurance policy, and we're done. But as Ben was mentioning, it's not, you don't just exit for just that reason. I mean, hopefully we can all live a little bit longer and exit and enjoy what we've been working for. And so it is getting that balance sheet right to say, well, can we buy them out? A lot of times when we look at the life insurance standpoint, if we're looking at funding a buy-sell for death, well, there's a lot of different ways you can do that. Life insurance is the most common. And you think about life insurance, well, there's a lot of different ways to skin that cat. You have your term insurance, your permanent, your universal, variable, whole, decreasing term, level term. And there's so many different names out there that's kind of up in the universe that you can consider. When we think about funding just for death, we almost always go to that term insurance. Hey, it's as cheap as possible. You get as much death benefit on that. Hey, great, we're good. We're golden. We've got that taken care of. And kind of while we're on that, when we think about the amount and the dates and the timing, I always say, let's plan for not where we are, but where we're heading to. So let's say, for example, I'm in business with Alex on my right here. And right now, my share in the business is worth $500,000. And so it says we're 50-50 partners. But I say within the next few years, we're going to be that $1 million number. Well, then do we try and fund for the $500,000 number that I'm worth today, or that $1 million number that I'll be in a few years? I mean, I generally go towards the latter because we know what we can qualify for and get in place today. Beyond that, when you look at the timing, what's an appropriate end date for that? That's really a case by case. So if you say I'm going to work until I'm 65, well, then try and find a term that matches up with that. If you're 50 years old and you say I want to work 5 more years, well, don't get sold on a 20-year policy to fund death on that. You're just kind of wasting your money on that. So work with your advisor to find something that's more appropriate for your time horizon, and for the amount that we need. So let me hit back over here.
Sure. I think at some point Alex is going to talk about funding cross-purchase agreements. So back on the law side of things, and we're doing the planning inside the organization, this technique is, what happens if somebody dies? That's an easy one, right? So how are you going to provide liquidity for the surviving shareholders to be able to afford to purchase the shares of the deceased shareholder at a fair price, or whatever price there is in the formula that's in either the shareholders agreement or the operating agreement. And so you can use what's called a cross-purchase agreement technique. It says, you die. If I die, my law partner has to buy my shares, forcing him to do so. And how that can be funded is because I have a life insurance policy or some funding technique that pays in a tax-advantaged way and provides liquidity for him to buy my shares from my estate or from my trust. It can't be my trust in the law business because we have restrictions, but so you have this technique that, and you can. So how do you secure it? Somebody has a life insurance policy. Well, those things are valuable, and so there's a question about, and there's some tax planning income tax planning that has to go along with it. You want to make sure that the incidents of ownership of the life insurance policy are with the right person, so that you get a tax-free death benefit, no income tax if you do it the right way. And so you have to have things separated, but it's not rocket science. I mean, we do this every day. But you just have it, and you can use a trust to hold the policies. You could form, for example, an irrevocable life insurance trust. Have that trustee go out and buy the policy on this life, and then another trust buys the policy in the other shareholder's life, and then there's a requirement that says those proceeds must be used to purchase the shares of the guy who just passed away. So that's a death situation. There are other techniques for disability.
Yeah, while you're on that, I just want to bring up one real-life scenario that I've seen years ago, and I'm sure it's not the only time. And when we think about that buy-sell agreement, that planning, we get along with our business partner very well, okay? All right, so let's say we have that buy-sell agreement. We have the life insurance, whether it's a cross-purchase, as Mr. King mentioned, or another strategy. Well, let's play this out, all right? So if something happens to me, I pass away, I'd love for my wife to get the liquidity from this. So I'd love for Mr. King, if he's my business partner, to take that liquidity from life insurance policy and buy those shares out. Well, and that works out very well, and generally that's what everybody wants. Mr. King does not want to be partnered with my wife, I'm sure, although she's lovely.
I don't know.
He doesn't want to be partners with her, and nor does she want to be partners with Mr. King, although he's very nice as well. So how do we handle that? The one situation I just want to mention that's worth thinking about is, should we force distribution? Should we force that remaining partner to buy that? So you mentioned the trustee and having the trust to do that. Because I have seen one situation whereas the surviving partner said, well, thanks for the liquidity. I don't really feel great about the future of the business. I don't think I want to own all of this business. So let's just kind of pay a little higher salary and kind of move on and not really worry about the shares of the business. So that didn't work out quite as well as he had hoped. So there's definitely things to think about on that.
So as long as we're talking about death and dying, Ben, what's the company going to do now that its major revenue producer, or half of the revenue producer, just exited, and all of the life insurance money went to fund the buyout of his shares, but that cash went outside the company. Now the company's left with a lot less revenue.
Yeah, thanks,
Yeah,
Kim.
sure.
Well, and this is the question that we have. If you are an operating company right now, people in the room are in business, or you have clients that are, and you say, what are the options, what are the things that we need to consider planning for right now? You have an operating agreement, whatever type of corporate entity you are, and one of your business partners right now, something happens to them. So if there's a death, and then there's a change of ownership, what is your plan? Do you have a plan? Or are you going to be reactive in a high emotional time to whatever that circumstance is you found yourself in? Okay, the death side, that's an easy thing. That person is no longer contributing income to the company. Where's the money go? Does it go to the spouse? Does it go to the company? That same question applies with disability, which is a much greater probability of occurrence. So suddenly you're disabled, you're a main contributor to the productivity revenue of this corporate entity. Is your spouse at home getting the disability check, or is the company? And do you have within your corporate agreements provisions that require or set forth a pre-agreed upon set of circumstances? Here's what's going to happen when you can no longer be a positive contributor to income. Here's what's going to happen when mentally you have an onset of something or physically that's keeping you from doing your job, as opposed to, you know, Dave's not pulling his weight. What are we going to do? What can I do? Maybe I'm the 20% owner and not the 80% owner, and I'm looking up saying, okay, what are my options here? And so setting up the proper legal agreements, I don't know, do you have a boilerplate system of things that you run down that you say these should be the things in the agreements? And ultimately this comes down to you're in court arguing this stuff if it's not set up in your legal documents up front. And so that conversation you and I had the other day where do I explode the company and just do litigate to death? Or do we find an unhappy medium for both and we both walk away and the company lives? Well, mediation doesn't mean you don't have a lawyer you're paying for.
Right.
So how can you button up your legal agreements as best possible? But once again, referring back, people in the room are in business. And so now they have an existing document, and what do they need to address within it in order to make it something that's safer so that the corporate entity can live on?
In our practice, like most lawyers who do the kind of stuff we do, we're checklist driven. So we have, you know, lots and lots of scenarios that we've lived through, and so we have our own checklist. We want to make sure that the clients have at least thought about these possibilities. And so the conversation we're having right now is, you know, a part of the larger conversation we have through multiple meetings with clients who are business owners about transition issues. I thought maybe this would be a good time to talk about the connection between personal estate planning and business planning, because there's substantial overlap. So if you're talking about, my complaint is that as business owners, we don't plan and implement. Mostly, and we do a lot of planning and then we fall down on the implementation. So how do you get back on track? Suppose you were to leave today, and we'll talk later about teams, but if you were to say, okay, I'm resolved, I've been reminded now of some of the risks that I face, I want continuity of my business for a lot of reasons, what would I do about that? Well, you'd start with basically a legal audit of your business. It's checklist driven. You figure out, what do I got? You know, who are the people on the team? And every business is unique, but there's some overlap among all of them. And so you figure out, what have I got in terms of bylaws, buy-sell agreements, all the stuff that we want everybody to have. But then I'd also look at my own. I'd want you to look at your own as the business owner or co-owner. What do you have? Do you have your ducks in a row at home with your own balance sheet? And so you'd want to make sure that you have your own estate planning and life planning done. So, you know, you probably, if you've got an ownership interest in a company that's, you know, it's spinning off a bunch of money, it might make sense to move ownership of that company, your shares in its corporation, into a revocable living trust that you have. So that's a management tool so that during your own incapacity, there'd be a seamless transition to control over those shares so somebody could vote those shares and keep the company going. You could vote a new board of directors if you needed to. So, you know, a trust-based plan with a pour-over will, that's just very, very ordinary, but very important to do, and then you actually need to fund the trust. But all right, so that's death planning, and it connects to the company, because you might put your ownership interest in there. You might have some interests that are not inside the company. Maybe you own some rental. In Tallahassee, our practice has lots of families that own rental properties on top of the other businesses they own. And so sometimes they're scattered and they're hard to manage. I mean, it would be hard for a successor manager to step in and run. And so what you can do is consolidate those, move them all into some clusters of LLCs, and then move ownership of the LLCs into basically a holding company. Is how a revocable trust would operate in that situation. So everything's organized for the next person to come in and run your affairs during. So, you know, you can have a stroke and you're going to be out for a while. You're not going to die from it, but you're going to be out for a while. So why would you want a gap in the management of that business enterprise that isn't part of the family business. And then in terms of life planning, I just want to put this out here. Every one of us in this room needs to make sure that you have a durable power of attorney that allows somebody to manage your money when you're incapacitated. That we call that part of life planning. You want to have a designation of healthcare surrogate, meaning somebody who can do your healthcare is a power of attorney for healthcare is what it is. They check you into a hospital, get access to under a HIPAA release to your medical records so they can help with an informed decision as to the healthcare you're going to get. I always tell estate planning clients that if you wake up going down the hall on a gurney and they're going to take you to some kind of surgery that you decide you've heard about you don't want, you can wake up and tell them, no, I'm not going to have it. You can countermand it. So you're not giving up all control. That was a joke. That wasn't very funny, but sometimes it works. And then you want to have a living will. You know, how do I want to go out? Do I want to die with dignity, or do I want to be kept plugged in to a bunch of tubes, and then I want to have firefighters come in and try to revive me because that's their rule, and I'm going to break all the bones in my chest, and now I'm going to die not only of the cancer that I have, but also in pain with broken bones in my chest. Why am I going to do that? No, I'm going to have a living will. And then I have a designation of pre-need guardian. That's the last sort of document in this suite that we want every family business owner to have. And that is, we're going to avoid fights over who should be mom or dad's guardian. Sibling fights over who should be mom or dad's guardian are really expensive and really the most nasty. We don't do family law, but this is the closest thing we get to it. And those things can typically run $100,000 in one sibling's fees just to get that fight over who should be mom or dad's guardians. This is for families with money. But even if they don't have money, then it's still a really unfortunate, nasty fight. And it's avoidable through planning, through what's called a designation of pre-need guardian. If I need a guardian, I don't want a guardian, but if I need one, here's who my first choice is, my second choice, my third choice. I can't see.
I'm going to turn over to Alex for just a minute. You're going to give some specific cases later on. But we're going back to Ben's question a few minutes ago, talking about whether I'm a sole practitioner, if I have 20 partners, wherever that might be. And Ben did a great job of saying, well, you're more likely to become disabled before the age of 65 than you are to die before the age of 65. Depending on your age, it's somewhere between 4 down to 1.8%, at times more likely on that. Some pretty, I won't call them interesting stats, but again, I'm a stats person. And so when you look at planning for things like that, again, whether it's a family-run business or otherwise, what are some things you should look at to help make sure you can continue to run the business, pay the bills, things like that?
Okay. So my role with the bank is really very specific to implementing solutions that fit a business owner's needs. And so what David and Ben were alluding to, it was a specific example. Last 2 weeks ago, a client, you have two business owners that own a retail construction company. One is older and married with children, and the other is single. One of them had gone through planning to look through and do this kind of mental checklist of where they were and what they needed to do to fill the risk gaps. And it was not the older married gentleman with children. It was actually the younger individual that was single. So it just kind of gives you an example there, right there, that you never know who is looking at planning and who should. Mentally, you would say it would be the older gentleman with children. But through that process, and we sat down with the two business owners, disability insurance was a big concern to the single gentleman. And as he was speaking to his business partner, they both kind of came in the room and said, let's look at this. And through the conversation, as they're debating, you could see them thinking, going back to the buy-sell, all of a sudden saying, we need to revalue the business. We think we need to up our coverage for the buy-sell. We kind of covered that piece. But then when we really talked about disability and your more likelihood of not being there on a full-time basis, all right, so what even constitutes a full-time? Maybe you got hit by a truck but not bad enough and you only show up 2 days a week. Well, there's provisions and policies that can cover that. There's provisions and policies for disability that will actually cover for coverage of loss of operating income. So there can be policies that are owned by the business and that pays just for that bucket of monies. We would want, if it's a specific disability policy, we would want the owner to pay that policy himself for certain tax reasons. But that's a good example of two business owners who were debating through gaps in their buy-sell and their operating agreements and seeing that there was some coverage that needed to be protected. And I just wanted to, the more you come to us and say, these are the concerns and I have, and I would think it would be the same with Kim. The more you can lay out what you're envisioning, the better we can fill those gaps for you with the different structures and products that are available in the marketplace. And they do change over time. So the products don't stay stagnant, and they evolve as well. And I can speak to it later, but there are instances where people have certain mindsets in place that may have been the case 10 years ago, and that if that's the case that stops someone from implementing a plan and funding a trust or funding a buy-sell, that's a dangerous place to be. And I can give you some good stories that you don't want to run into, but that's what we do. I mean, I think if anything that I leave today is the more information you give us of what you're trying to achieve, the better we can implement the solution in place to solve that for you or mitigate those risks for you.
You know, thinking about that client you mentioned a minute ago, as we were going through the plan, one other thing that was a bit of a shock is we always like to review the property and casualty insurance as well. So we don't really think about that when we think of business transition, formation to exit, but that's extremely important for the business owner to make sure we protect what we've been building. And so that was a bit of a shock. They thought they had a fair amount of liability coverage, which they did not. And so I always recommend you talk to your advisors, review those things for any business owner in here. Use this as an opportunity to take a look at what you have there to make sure you don't have those unintended surprises. And I think that's a lot of what we're talking about. Surprises either now or after I transition down to the next generation, wherever that might be, or sell to somebody else. We got to plan for the what ifs. Let's plan for those. Let's plan for what we can control to be ready for what we can. And that's one of those things that will behoove you to take a look at.
So Ben just slipped a couple of questions my way, and I thought I'd just try to talk about one of them. So to give an example, if you want to bring somebody in now to an existing business, a new shareholder, for example, in a corporation, or a new member in a limited liability company, how are you going to do that the right way? So if you don't have I'm sure that everybody out here is doing business through an entity of some kind, a corporation or a limited liability company. There might be a few partnerships still out there. We don't write them anymore. We just run everything through LLCs, unless it needs to be and even you can have professional limited liability companies now. But so you're going to bring somebody in, you're going to sell them a piece of the action, right? So you need to have an agreement. You ought to give them a disclosure about the company. Open everything up. You're going to want to have an agreement going in. If you're going to appear inside our company's records, we're going to have some restrictions on your ability to use that information later. Confidentiality agreement, non-disclosure agreement, sometimes we call it. So you guys, he's coming in, he's going to get if it's a he, is going to get a certain percentage, you agree on that, and he says, okay, I think that's worth X based upon my expectations of what. So, is this guy coming in, and you need to have this part of the conversation, is he going to get compensated? So he's going to get a piece of the profits because he's an equity owner later, if there are any, but is he going to get an employment? Is he going to get cash flow through an employment relationship now? If so, let's talk about that coming in. Let's have a written employment agreement that has maybe a non-compete built into it. We're going to have the salary built in there. We're going to talk about fringe benefits, retirement plan, cash flow, distribution. I mentioned distributions for taxes. Budget, for example, if this is a guy like a lawyer who's a revenue generator, is this person going to have a budget and a share of overhead allocated to him? We need to have that kind of spelled out. How about income tax effect? Is it a subchapter S corporation? Are we going to make sure that as an owner, when he comes in, and you'll do this through the subscription agreement, which is a contract to buy the stock, right? We call it a subscription agreement. Is he going to agree there that he's going to do everything he can to maintain that subchapter S election status so that it's a pass-through entity, so that all the tax attributes pass out, so there's not like a C corporation where all the taxation happens on the inside. I'm not a tax lawyer, but I know that much. And then how are company assets going to be reused? I mean, are you going to have restrictions on personal use of the company jet if you got one? How about productivity? How about behavior in the workplace? We have in my firm, I know this is videotaped, but I just have to say it in my staff cringes every time I bring in somebody new. I say we have a no assholes rule in our law firm, because I've worked in law firms where people ran around and they're litigators, and they behaved in their relationship with the guy in the office next door, who's their colleague, the same way they behave in the nastiest of fights with really, really ugly Miami lawyers. Miami lawyers have a reputation that's well-deserved as they're assholes. So we have a no assholes rule in our firm. So it's firm culture. So you're coming into our firm, how are you going to behave? Or we're not going to put up with it. I want to know, before you come in, am I going to enjoy spending my time with you? Are you a good fit for us? So we're going to have, it's a two-way conversation there, but he's going to have some expectations explained to him, and he's going to, there might be a probationary period, don't know. And then we're going to talk about business ethics. So lawyers have all these ethics rules that we know and we try to follow, but business owners who aren't licensed like we are, I think, ought to hold themselves to some standard of business ethics. I mean, there are crimes out there, okay, that's a really, really low bar. Commercial bribery, that's a crime, but you're not going to do that. But you ought to also have, we have a firm culture of honesty with our clients, our customers. We try to provide the best service. What's our firm culture like? We want them to know that coming in. So the person's got to have that conversation with us. He might have an employment agreement. He will have a subscription agreement. And he will, when he signs that contract, it's a contract to buy in, a deal where he's joining, as a joinder agreement is built in typically, he's joining in the shareholders agreement or the operating agreement says, which has already built into it how he gets out, has all the exit stuff that we've already been talking about.
What are those exit things?
So, when I die, what happens to my stock? Is there a forced sale? Is there a cross purchase? How's the funding mechanism for that? How's the valuation of my exit going to take place if I,
Let's spend a minute on that.
Yeah.
What are the different valuation methods that you're going to build in?
I'm going to
Because
give
you don't want to
real-
discuss that
Yeah.
when you're having to do that becomes a fight in and of itself.
Let me give you the lawyer's perspective, and then I'll hand it over to the money guys. From my perspective, when I'm drafting these things, the clients have choices about how they're going to design a formula for pricing later, right? So we're drafting a document now, and the guy may not die for a long time, but it might be 5 years out, and they haven't changed the shareholders agreement. This happens. We do them, and they go on the shelf, and nobody pays attention to them, unfortunately. But so we have some choices in drafting these pricing mechanisms, and so I mentioned this earlier a little bit, but you can have an agreement through your shareholders agreement on exit. It's going to be based upon some multiple of earnings, or it's going to be some enterprise value derived from some other formula. We might have a formula, an agreement that says we'll stipulate to a per price share at the end of each year, and we'll amend our shareholders agreement that way. If we fail to do that and it's gone for 3 years, then that price goes away, and we have a mechanism for we bring in an independent appraiser. We might fine tune that and say, okay, those guys are expensive, by the way, but we bring in an appraiser, and then if you don't like that appraisal, then you can hire your own appraisal, and then we might have like a tiebreaker mechanism for that, for what's the price. Then we have the purchase terms, like how long is the payout? Is it going to be some seller finance, some seller financing? So spread it out over time so that we don't put a tremendous cash crunch on the business while it tries to, or the other shareholders, while they're trying to recuperate from the loss of this guy who left.
So let me just
Yeah.
say,
So one of the things that when we were doing our planning, we talked about is triggers.
Yeah.
There are triggers that can occur. So there's the voluntary, hey, I want to go, I need to go. And then we have to refer back to the document we've created that has indicated what agreed upon valuation method we will use. And there are options, and they vary by industry. So it's a different different valuation method type for the different type of business that you're in. But one of the considerations is, okay, the four of us are in business, and I'm the predominant decision maker on what to do with the cash of the company. Are we distributing it? Are we keeping it within inside the company? Well, if I think time is coming and you're not pulling your weight, and we're going to work our way to getting you out, so now we're going to change the way that we're going to operate and use our cash within the company. We're going to do some expenditures to expand. We're going to invest our money into non-liquid assets. We're maybe going to slow pedal some things, make some pre-purchases of items that are going into inventory for future use, and hold back on some reception of funds. So now when it's time, when we hit our tick mark for doing our annual tax returns, guess what? We had a tough year. So now we're going to do this valuation method that we've agreed upon that I've just manipulated to lower that value. Another question becomes, if I'm the primary breadwinner, it's Ben LLC, and I've got you guys working with me with minority
partner shares just so that you have a piece of the pie. At the end of the day, if I'm the primary rainmaker, what is the value of the company without Ben? Is it really that I can step back and I'm overseeing and you can plug and play another replacement me in my place and the value of the company is somewhat intact? Or if it's really based on me and I step out, what do you get in return? And how does that valuation look at those residual income factors and value assets of the company that are in fact left over? These are all things that you guys have to consider. But at the end of the day, what he keeps saying repetitively is, you have to have a conversation. You have to think this out. There are tick marks and check marks that they're going to run through when they're creating your documents for you. But you have to know what those plans are and think through what your end goals are. But more importantly, and hopefully what we're making you consider is, there are involuntary things that will occur. There are unexpected things that will occur. And you need to have those laid out into, let's refer to the document, we don't have to discuss it in court. We can refer to this, and that will lay out the plans of action that we will take moving forward.
So when you're discussing the exit and the valuation, I mean, just sometimes it's helpful to hear what other people do and what we've seen over the years. Commonly, we'll have valuations based on two high-level different triggering events. We'll call it death and anything else. All right, and so that's what you see a lot of times, because we know the death exit, that one's easy to fund, right? You know, term life insurance policy costs a couple $100 or maybe a couple thousand tops. Hey, you're done. Hey, take care of that. Partner's gone, liquidity's there, not a problem. But I mean, you're bringing up a good point, Ben, that, well, how do you fund this for all the other things? Disability, divorce, retirement, moving, just inability to get along, whatever those other things are. It goes probably to that balance sheet. Hey, make sure you're ready for these types of things. But also, well, how long should we have the buyout for, and how should we appraise that? Sometimes we see agreements that will say that we're going to have an independent appraiser come in, the departing member can have their own appraiser, the selling member, the buying partner can have their own appraiser. If they don't agree, they can each hire a third one to come in, and you can spend a lot of money on appraisals, but that could work. Sometimes you see something that's based on future income of the business. I don't like that one as much, but I mean, we see that sometimes where it says, all right, if one of us exits for whatever reason, we're going to pay that departing member 25% of net income for the next 5 years, and then we'll kind of call it even. And so next year they'll get 25% of that, then after 5 years, you're done. And then we'll kind of have a caveat, well, if they did depart for death, well, we can use life insurance, pay them up front, and forget about the whole net income down the road. I don't like that one as much because that's so hard, it's so easy to manipulate. It's so hard for you to know what your family would get in that. I always like having an appraiser to come in at the exit to value those shares, or you can look at historical numbers, which can be good, can be bad, right? You know, before the crash, that would have been, I guess, good for the departing member if we look at last year's tax return and value based upon that. But those are things that we see a lot of times. What I will say, you know, we've been spending a lot of time chatting about exit for, you know, all these things that go wrong. I guess, you know, a lot of us are in kind of the risk business, so we're kind of, I guess, by nature like to sit home and say, hey, if I were dead, what would happen? But, you know, let's talk for a few minutes on planned exit, because that's kind of fun to talk about sometimes as well. You know, we're all, you know, a lot of us here are business owners. We're all in business. We're all doing what we do for a reason, and that's for the end goal. And so when we think about planning for your business transition, I always look at it as a kind of a 6-step process. Ben mentioned to start the presentation that I'm a certified business exit consultant. That's through Pinnacle and Allstate Group. But through that, we really work on a 6-step process on that. And that first one being just like with any plan, like whether it's a financial plan, a business plan, whatever that is, you always start with the end in mind. And that's really what you have to do. All right, so we need to focus on the what ifs, the bad things that could happen, and that is important. And it's important to think about. But let's start with the end in mind. What does retirement look like for you? How do you want to transition to business? Don't try and get wrapped around the axle of how to do it and try and figure out the solution without talking to a qualified attorney or CPA or other advisors, because that usually doesn't end up that well. But think about that end in mind. And it kind of takes me to a good analogy of I was hearing on the radio the other day of just younger generation of things they don't know about, you know, things they've never seen or never experienced, and that's, of course, a loaded topic. But one was maps. Remember paper maps, you know, before all the Googles and things like that? And the conversation was, Well, back, I remember when I was a kid taking family trips, we could go to the AAA store, right, the AAA, and get a map from them, and they would actually kind of plot out that course for us. We would say, hey, here's where I'm starting, here's where I want to end up, help plot out that course for me. And definitely use your advisors for that. Don't try and get wrapped around the axle up. I think this is the direction it has to go, so let me take these steps on my own. So, kind of a long way of saying, start with the end in mind, and kind of come to us or whoever your advisor is and say, here's where I want to get, here's my time frame. I want to exit at such and such date at age 65, and I think I need $1 million. And I would love for my minority business partner that owns 20% to buy me out. I really want this to stay within the family or within the current employees. That's what I want to have happen. And then let us start to work on those numbers for you. When you think about that, so you start with the exit in mind, you start with understanding what your goals are. Then there's the next step is really looking at two things. The first one is easy. That's financial readiness. All right, that's when you look at the value gap. Okay, so I have my own business. I know I want to sell and retire at age 65. Here's the assets that I have set aside. I've worked with my financial planner, and they said, hey, based on what I want to spend, here's what I need a net from the transaction. And remember, that's net, not gross. And you can talk to any CPA in here. They can really discuss the difference on net and gross and how the taxes work depending on how you transition the business. There's a lot that goes into that, by the way. There's multiple ways to do that. But what do you need a net for this transaction? So let's work with a planner to figure that part out. And the other part of that I really enjoy is the mental readiness. And that's the part where a lot of people kind of stop and say, well, let's think about that. What are you going to do? Do you visualize transitioning to business and staying involved for 3, 5, 10 years? Whether you sell it to an employee, a third party, the next generation, whoever that is, do you visualize staying involved? And I will say a lot of times that starts off good, and then they get tired of you coming to the office all the time. But there's lots of ways you can do that. Or you have the mindset, I'm done. I want to be out today. If I never see this place again, I'm happy. I don't care what, I'm out. And so you really got to look at those two different quadrants, that financial readiness and that mental readiness. And if you kind of combine those two, it can really help you figure out, well, what are my options? All right. And through that, we actually do something called a Berry report, Business Exit Readiness Index. And that's really 20 multiple choice questions. It really helps you understand both at least your perception of your mental readiness and your financial readiness. And it does a great job at giving us 4 quadrants, if you will, of what type of exiting business owner you are and kind of where you are at that stage. Whether you still think you want to work for 20 more years, or you have that proverbial 5 more years and I'm out, which we do hear a lot. So as you do figure that out, do you have the conversations on your financial and mental readiness, and this is, again, the planned exit, which is the fun exit, right? There's 4 main types that I always like to say. The first one is that get me out right away with the most money, all right? So I'm ready to go. I need a net as much as I possibly can from this transaction. I haven't really listened to a financial planner and saved a lot on the outside. I got to get what I can out of this, but I'm ready to go. And so what are some of the things, the most common one for that is really a sale to a competitor, which is how these conversations start a lot of times, is a competitor approaches our clients and say, I want to buy you out, here's what I'm willing to give you, and that's always fun because, one, the seller sometimes think that's the only option, which couldn't be further from the truth. And oftentimes, I had one guy who liked to buy businesses, said he always had a strategy that he'd always start by offering them an amount more than he was planning on paying to really get them interested. All right, and then you start going through the diligence process, and he had every intention of bringing that down. But he said, well, my goal is once they start thinking about selling, it's in their mind. And then all of a sudden, maybe they, in their mind before they started, they said, I need at least $1 million. But once the process starts, you think about if you're buying a house or a car, whatever that is, you tend to rationalize and justify, and your boundaries shift a little bit. All right, so whenever you're talking to looking at a competitive offer, just kind of keep that in mind, whether you're looking at buying or selling. There's some interesting things to do. So that's one of those. The other of the 4 quadrants, so we call it the well-off, but choose to keep working. All right, so hey, I'm not really ready to go yet, but I've got everything that I need. So it's not that I need a net a lot from this transaction. I don't have to sell it to a competitor for the most possible money. So if you look at that, that's a great way. If you say, hey, maybe selling it to one of your employees. Maybe that's a great way to do that. One of your employees wants to buy you out, Well, we always say on the planning side, you got to count on what you get up front, and if you're selling to your employee, you just kind of never know what happens, especially if they start taking over and making the decisions. You always kind of got to plan on, we always, in the planning process, whatever you get up front, we put into the plan. Whatever you expect to get, we'll have a lot of conversation. Do we want to really include that in the plan or not? All right, and so those are things that you can look at there. That's a great strategy for gifting to the next generation, or even some ESOPs plan work out really well for that. I kind of want to stay involved a little bit. I want to start helping out the next some of the employees there. The employee stock ownership plan that we hear about a lot. That's an interesting concept.
What's the size that makes sense for someone to look at even considering an ESOP?
That's a little bit of a loaded question. So there'll probably be disagreement, maybe a little bit of grumbling, but there's no maximum on that. For a minimum for ESOP, generally the rule of thumb is 10, preferably 15 employees at a minimum to consider an ESOP. A value, some people go as low as $500,000. I really say minimum of $1 million to really make it make sense. The reason for that, an ESOP, employee stock ownership plan, is a great concept. In theory, it works out well, and in practice, it can work out well. We all know Publix and a lot of other large companies have those in place. It's a great way to reward employees, keep employees happy, reduce turnover, and benefit the employees, and also make a market for your stock. ESOPs work out really well if you have a business that you want to start getting some money out of, but it's not quite big enough, or you're not getting the attention of a competitor or private equity group that wants to start buying out some of your shares, or a third party that wants to buy into your company. Well, this can be a little bit of a market maker for you sometimes. It can be a little bit of a liquidity provider. And so you will see it for that. But I always say, plan on, a minimum of 10 to 15 employees. I'd like to say $1 million for value, just because you do have, a fair amount of fees to get it set up and annual valuation fees and such. But that could be a whole topic in its own, because ESOPs are a wonderful strategy. There's roughly 10,000 or so in the U.S. today, and we can get on that at some point. The third main thing is that we always like to say, you kind of stick around and let the business grow. So that's like where a lot of us are. I'm 10 years out. I need to find a way to start saving money on the outside. I'm not really ready to go. I'm that 5 to 10 years out strategy. And so you can do some interesting things there. That might be one. If you say, hey, I want to be out within 3 years, I think the business is a good value now, but I really see something happening, but I'm not comfortable having all my eggs in this basket. Well, private equity groups, things like that, I've seen that work well a lot of times. And how that works is generally you want to be of a certain size, and they'll usually buy a controlling interest to start. A lot of times you see around that 80% interest they'll buy up front. They'll generally want you to stay on for a few more years, all right, so that's good. It lets you continue to earn income, stay involved in the business. And what a lot of those departing members like with that type of strategy is it lets them have a second bite of the apple. All right, so I sell 80% now. I partner with this firm, this conglomerate, that should have a lot of vertical and horizontal integration that could really take my business to the next level. And then my 20% interest down the road in 3 to 5 to even further out years could be worth as much as 80% was when I did the first transaction. And I've seen that happen, and that's definitely something to consider. The finally is we always call the rich and ready to leave. Hey, I've got what I need, kind of ready to get out, and we have seen some great strategies of whether it's gifting, so we talked about that already, so I won't belabor that anymore. Transitioning to charity, set up foundations, which Mr. King can chat about. So there's some wonderful things you can do there. Kind of what I'll keep in mind is the fourth main step of this process is to kind of learn and choose that option. All right, so we talked about based on where you're on the quadrant, what are your options? So again, never think that if you're approached with a value, with a strategy, that's your only option. And never think it's all up front or all stock. It's oftentimes we'll see maybe it's 50% up front and then an earn out, retained income. There's a lot of ways to do that. Again, your CPA will really do wonders in helping you understand the net impact for you on that. Really start to run those models out, and your financial planner should be able to help out to model that out for you to say, does this make sense? I've seen some business owners that were starting that transition process, but I gifted away a fair amount of the shares of the company, so they got a price on the company that seemed very reasonable, very fair, but then when you actually start to run the numbers of the net, you have to factor in the taxes and the loans that we have outstanding, which we got to pay back, and also the fact we've already given away a percentage of the company. Well, what you net after all those other things come out, it's important to start to run those numbers there. I will say that when you look at valuations, because as we discussed earlier, a lot of times that business represents roughly 80% or so of that total net worth. I challenge all of you business owners to take a look at that and say, how much does this represent of my net worth? So how much do I need this to really work out for me?
So some of the things that we've seen in terms of the ability to sell your company, a piece of it or all of it, if you are a standard traditional operating company and you want to sell a part of your company, then chances are you're going to be the one providing the financing, because the bank can't take a fractional ownership of your company and just be a 20% owner of it. Now, we might be able to give you a loan that you can use discretionarily for that purpose, but it's not that, it's got to make sense from a cash flow perspective. It's not that we're really taking a stake of ownership that we can do something with your business. So what we often see in those circumstances, often in professional firms where you want to bring somebody new in, is somebody will, the firm will say, your price is this. And if you are an owner for this new percentage stake of the company you're going to get, you would normally get a distribution. That distribution oftentimes is used to fund your buy-in for the portion. So you're lowering what your income would be, in essence, for some period of time, for that firm to become the financier of it until you've achieved the full payback, and then you can participate in those distributions. If you go for SBA financing, there's an interesting piece of this. If you sell your company, you're only allowed to stick around for 1 year. So we were talking about these other types of sales that allow you to stay around in maybe a part-time advisory or other capacity. But if you do an SBA loan, you get paid off and you think, well, I'm just going to stick around for a year and help you out, that's fine. You can become employed for that 1 year, but after that, you're required to exit that company. So just keep that in mind. That's one of the interesting things. SBA is nice in that it will give you a 10-year opportunity for payback of that loan. So think about what that's going to be. I'm going to buy a $500,000 company. And so, just divide 10 years into 500,000, add the interest on top. You've got an idea what that debt service is going to be for repayment. Now you have to really take a look at the company finances and see if it makes sense. We are coming off the longest economic expansion period that the U.S. has realized. How long do we get to continue that? Well, if you're buying a company today, or if you're valuing a company today, if it has been in an industry that is benefited in this economy, you're looking at the highest value right now. If you're thinking of selling, it's a good time to sell. If next year the economy tanks, your valuation just went down. So everyone remember when Time Warner bought AOL? Was that great timing? For who? Right? I don't think AOL is thriving so much anymore, and they paid a premium for that. If you were Yahoo and you were getting acquired and you happen to have your data breach incident, which I'm a big fan of talking about, Verizon didn't mind that happened. It changed the valuation of the company, and it benefited them by paying a much lower price. So the timing of this execution and your decision to exit, or to sell a piece's part, or to buy in, if you're someone who's considering becoming an increasing share owner, is related to that valuation in a big way. Pay attention to how the company is discretionarily using the funds that they have. Pay attention to the external factors and the trends that might affect what you ended up buying. Another example we saw was a certain business in town where the owner held the financing note. They were going to hold it for a year, kind of let the guy, as the new owner, get his sea legs under him, and then he was going to execute on a bank loan, proving that he had the experience under the wing to keep the train on the tracks. Well, there were a number of factors outside of their control that negatively affected the income of the company, and he was no longer able to service his own internal debt. So the business owner basically foreclosed or retook over the ownership interest of that company that they were seller financing. So what was his loss? Well, nothing really, because he got the down payment out of it, he got the key. The employee was still employed, he kept him in the managerial capacity, but he regained full ownership interest of the company in that sense. So what is your participation in here? If you decide to go down the SBA route and somebody says, look, I'm really concerned about building up some liquidity
after I execute the sale, SBA lets you do 10% down, and you as a seller can hold a 5% note, but you're not allowed to get repaid on it while the SBA loan's outstanding. So just things to keep in mind depending on the structure of who you sell to and how and what the timing is and what that means to you.
You want to talk about the minority control ownership for business, the 51%, and how you put your agreement in place on that?
Just a couple miscellaneous topics. I just wanted to make sure that when you're doing, I'm going to start with something different, but I'm going to come back to that. When you're doing your planning, if you get back on track to do the planning, and you start with what I call a legal audit, but you just want to figure out where you are and where you need to go in terms of what tasks remain to get your affairs in order, internal to the business, and then on your family side, because they all overlap. When you do that kind of review, one of the things you want to look at is preservation of value in a different way, and that is asset protection. So as part of our estate planning, when we do it for business owners at our firm, we do all the planning for the estate stuff, everybody, all the documents are executed. We start getting assets moved into trusts if it's a trust-based plan. But we also, as part of that same conversation, we ask our clients to look at their own risk management issues. And so you want to make sure that from an asset protection perspective, because that's the time to do it, because you're already involved in looking at opportunities and risk exposure. So you're going to look at opportunities to shelter, and all this stuff is perfectly legal. You can't do it after you've got a judgment against you, and you try to move money around, then you've got a problem with fraud on your creditors. But you look for opportunities for exemptions. We have physician clients, and they park a lot of money in life insurance because under Florida law, it's exempt from creditors' claims. You can put money in your homestead. You can pay off your home, for example. If you've got enough money that you want to preserve wealth, at least know that in the worst case scenario, at least I'm going to have a roof over my head. We'll pay off your house. In Florida, that's one of the best protected assets one can have is your homestead. But you want to make sure you've got adequate automobile insurance. And this sounds crazy, but it's one of those little things you can overlook. If you don't have the right kinds of coverage, and this is the reason you need to go, we send our clients, go to your insurance agent, your home and auto insurance agent, for a checkup. And then when you're walking out the door, say, and I'm covered, right? And they panic. So you need the insurance checkup to make sure you've got adequate liability insurance, property damage insurance, and then it connects up to your umbrella liability insurance policy. I'm not an insurance guy, but this is what I want my clients to have. I have it. So it all needs to integrate so that your liability risk, and if you're at a professional practice, a physician, some of them go bare these days, lawyers typically don't. So you want to make sure that you've got adequate liability coverage for your professional practice. You want to make sure you've got flood insurance, because strangely, some kinds of insurance don't cover leaks from pipes, but flood insurance sometimes does. Windstorm used to be a thing. I mean, you want to make sure that when you have your checkup, you're looking for these areas of vulnerability, things that can really adversely affect your wealth and interfere with your ability to take less on the sale of the business, because you know you're going to have enough money to live on. I don't have to get that price. Maybe I'll get a better price to the next generation because I want the business to continue. I don't have to pull that much money out of my business because I've planned well on the other side. And so, yeah, so here's just a different topic. We're down to the random topics phase. So what if in terms of, so we're talking about, this topic is control of the company, voting control of a corporation or of a limited liability. If you're a corporation, you've got stock, right? And suppose you have just one class of stock, typical S corporation, all you got is our common stock. And somebody has 51%, and that would be my spouse, because I don't really have this, but if I did, she would do that because she wants to be able to compete with an advantage for government contracts under the minority contracting set-aside deals that are out there. And then what if my spouse and I later break up? And now she still has control over the corporation. Have we planned for that? Can we plan for that? So she could vote her stock to kick me out if I were involved in the business, fire me. She'd have control. She could squeeze me out in a bad way as a shareholder, as an officer. What kind of advantage, what kind of mischief could be made there? So you plan for those kinds of mischievous spouses on the front end when you're setting up the shareholders agreement. Now, there are limits on what you can do, because it truly, it depends on what the contracting requirements are, but it truly does have to be 51% control in the minority spouse, or it's not a spouse, but the minority owner. And so if you put your shareholders agreement, but really the voting is done this way, and then the government sees that, then you've probably committed a violation of something. I'm not going to call it a crime, but it's probably improper. So you have to think about, and how are these control issues going to come back to bite me in ways that I really can't perceive right now? Yeah. Do you want to add?
Yeah, well, no, that's a great topic there. I know we're getting kind of close to the time. I want to hand over to Alex one more time. Are there any other situations where, again, Alex definitely handles our investments, insurance, life insurance, long-term care, disability, everything that both our business owners and non-business owners do need. It's very important. Is there one or two scenarios you want to discuss of where insurance and even cash value insurance may have made sense for the continuation, ultimate transition of the business, and maybe even to keep our employees happy? Because as we know, it's a great economy right now. What are we doing to keep our employees retained?
Yeah, so what David's asked me and alluding to is there are a lot of pieces in insurance that can be advanced planning insurance where you can structure the continuation of that business by tying into those key employees over a longer term period by purchasing products that offer coverage, but then over time builds in a deferred compensation, if you will, for that employee. And you really can structure it in multiple ways. One maybe to benefit the employer more than the employee, one to be mutual. It really comes down to that relationship. And there's caveats in there, you know, what would happen if that relationship was to sever or that person move on. So there's a lot of ways that we can structure that and be creative to see a way to kind of further along what your true intended wishes need to be. And, you know, we talked earlier about disability. You know, we definitely have structures that can help clients there, but, you know, be aware that you can even have disability for the company as well if that one of the owners were to be hurt. A lot of people are not aware of that. I'll just leave with a couple pieces. If anything, if I stressed enough, is please fund these mechanisms, whether it be a buy-sell that Kim writes or a trust. I had two recent stories from coworkers, one on a buy-sell and one on a trust. Coworker had two employee or owners of a business, a $9 million manufacturer, and one of the owners, they had a buy-sell but didn't fund it. One of the owners passed. The requirement was that he had to pay out $4.5 million to the family. He had to take a loan with the bank. And the provision of the bank was, you need to insure this loan. So he had to go out and get insurance. So he had to get a loan, pay interest on that $4.5 million, and he was what we call highly rated, meaning he had difficulty qualifying, because you do have to qualify for insurance. So the insurance cost him just to borrow that money $60,000 a year, just on an additional loan. And that is just simply, it's a scare tactic of any mean, but there's a lot of unintended consequences that follow through when you don't fund or go all the way through on a funding of one of these strategies. And then on the trust side, I had a coworker tell me a story the other day that, you know, he's in the business and he says, my parents structured a trust and they have properties in 3 different states and they never funded it. And he's like, oh, on top of it, they wrote the trust in one state and moved to another state, which causes additional issues. And he was like, Mom and Dad, I would be probating in 3 states. And you know how much money it's going to cost? And so if you draft these documents and work with Kim and David as you walk through how you want to envision these things to happen, if you don't follow it all the way through, I would tell you, there's 2 types of clients we see. The ones who meet during this time period and are putting the planning in place, and we don't really see from their executors or trustees too often other than just following along and implementing in status as we go. Or we meet with the ones who didn't implement and didn't plan and have a lot of conversations on how to unwind things. And you want to be the former, not the latter.
So any last takeaways or examples as we wind it up here?
No, just from my side, I applaud all of you for really pursuing the dream and being successful business owners. Obviously, you're thinking about planning, otherwise you wouldn't have showed up here today. I want to leave with plan early, plan often. These examples Alex gives and Kim has given over the last hour and a half or so. If you plan early, plan often, you can really avoid a lot of this. We plan for the bad stuff, the what ifs, but let's talk about that planned transition, that planned succession. There's a lot of good that you can do with that business that you built.
I'm glad you're thinking about it. You thought about it enough to be here today. The key, and the planning is important, but implementing the plan, don't leave those stray properties in other states that we have to go probate in each one of those states. Implement the plan, move the assets around where they need to be, and then revisit the plan and its implementation. Find out your beneficiary designations, where you're pointing those assets, those straight assets on your accounts. How's your joint ownership coming along? There are lots of parts of the implementation of the plan that people don't come back and finish. And that's when we end up having to spend more time and money in probate court trying to clean up messes. So don't be that way. Finish the plan, finish the implementation, revisit it periodically.
Yeah, I'm going to thank you, of course, for being here. I'm hoping that the takeaways that you get are that you need to really quantify, put into a legal agreement, put into your operating agreement, have everybody on the same page with what the game plan is. I consider this a prenup. This is, we're all getting along, smiles, right? And so let's put together what we all want, what we're all on the same page about before we start disagreeing, because life happens along the way, and that's not, a litigious result is an expensive result. And it becomes an issue of, do we shut down this company and start our own new one? And what happens with reforming all of those things we need to put back in place. Talk to the banks if that's what your exit strategy is going to be, is blow up the old company and start a new one. Will we give you what you need for your operating lines of credit, et cetera, so that you can start over again? Because sometimes you can and sometimes you can't. It depends on really what you've got in place there. But the planning piece is key. So we'd love to have more specific and detailed conversations if you think it's prudent. And obviously we don't have these boilerplate answers. We have these generic questions and tick marks that we want to make sure on the checklist we give you to think through. But the answers to those and the variables and the nuances are really individual and up to you. And that's the important piece of this, is to have those conversations and thoughts and gather them, and then let's help implement them. So thank you all for being here. Greatly appreciate your time, and we look forward to talking with you more.